Welcome back, future lawyers. Today, we're reviewing Mercantile Law bar exam questions and suggested answers to help you master the concepts that often appear in the bar exam. Let's get started. Starting with part 1. Question A1, define the following terms: trust fund doctrine, fair competition, insurable interest in property, and splitting of deposits. Trust fund doctrine provides that subscriptions to the capital stock of a corporation constitute a fund to which the creditors have a right to look for the satisfaction of their claims. The scope of the doctrine when the corporation is insolvent encompasses not only the capital stock but also other property and assets generally regarded in equity as a trust fund for the payment of corporate debts. Unfair competition is the passing off or the attempting to pass off upon the public of the goods or businesses of one person as the goods or businesses of another, with the end and probable effect of deceiving the public. Passing off takes place where a person, by imitative devices on the general appearance of the goods, misleads prospective purchasers into buying his merchandise under the impression that they are buying that of his competitors. Insurable interest in property is every interest in property, whether real or personal, or any relation thereto, or liability in a respect thereof, of such nature that a contemplated peril might indirectly damnify the insured. It may consist of an existing interest, an inchoate interest founded on an existing interest, or an expectancy coupled with an existing interest in that out of which the expectancy arises. Splitting of deposits occurs whenever a deposit account with an outstanding balance of more than the statutory maximum amount of insured deposit maintained under the name of a natural or juridical persons is broken down and transferred into two or more accounts in the names of natural or juridical persons or entities who have no beneficial ownership on transfer deposits in their names within 120 days immediately preceding or during a bank declared holiday or immediately preceding a closure order issued by the Monetary Board of the Bangko Sentral ng Pilipinas for the purpose of availing of the maximum deposit insurance coverage. Question A2. In May 2018, ABC Corporation entered into a merchandising contract which terms and conditions were totally lopsided in favor of the counterparty XYZ Incorporated. As a result, ABC Corporation suffered tremendous financial losses. A year after, or in May 2019, Mr. X became a stockholder of ABC Corporation. Learning about the circumstances surrounding the merchandising contract, Mr. X filed a derivative suit against ABC Corporation's directors to claim damages on behalf of ABC Corp due to their mismanagement. Questions: what is a derivative suit? Was Mr. X's filing of a derivative suit proper? Explain. A derivative suit is an action filed by the stockholder in the name and on behalf of the corporation to enforce a corporate right or cause of action to set aside wrongful acts committed by its directors and or officers. The filing of a derivative suit is not proper. One of the requisites of a derivative suit is that the person filing the suit must be a stockholder of the corporation at the time that the acts or transactions subject of the action occurred and the time the action was filed. In the present case, the transaction subject of the derivative suit occurred when X was not yet a stockholder. In fact, X only became a stockholder 1 year thereafter. Question A3. In June 2018, DEF Corporation sent notices to its stockholders informing them of the corporation's issuance of new shares of stock. The notice included a reminder that, pursuant to DAF Corporation's Articles of Incorporation, any stockholder who fails to exercise his or her preemptive right within 3 weeks from receipt of notice would be considered to have waived the same. Ms. Z, a stockholder of DEF Corporation, failed to exercise her preemptive right within the said period. However, she claimed that she did not validly waive her right to do so because a waiver must be expressed in writing. Questions. Explain the concept of preemptive right under the Corporation Code. Is Ms. Z's contention correct? Explain. Suggested answer. Preemptive right is the right of the stockholders to subscribe to any and all issuance or disposition of shares of any class by the corporation in proportion to their shareholding in the corporation. This means that, except in cases provided by law, shares of stock of the corporation should first be offered to the stockholders prior to any offer to non stockholders. This rule is intended to prevent the dilution of stockholders' equity stake in the corporation. Z's contention is not correct. Preemptive right is not absolute. It may be waived expressly or impliedly. Failure of the stockholder to exercise his right within the period set forth by the corporation amounts to a waiver of preemptive right. Question A4. In 2016, X Corporation obtained a loan worth 50 million pesos from J Bank, which was secured by a third-party mortgage executed by Y Incorporated in favor of X Corporation. Since X Corporation was not able to settle its loan obligation to J Bank when it fell due, and despite numerous demands, J Bank foreclosed the mortgage properties. The properties were sold in a foreclosure sale for 35 million pesos, thereby leaving a 15 million pesos deficiency. For failure of X Corporation to pay said deficiency, J Bank filed a complaint for sum of money against X Corporation, its president, Mr. P, and Y Incorporated. With respect to Mr. P, J Bank argued that he should be held solidarily liable together with X Corporation because he signed the loan document on behalf of X Corporation in his capacity as president. On the other hand, J Bank contended that Y Incorporated should also be held solidarily liable because the shareholdings of both corporations are identically owned and their operations are controlled by the same people. Hence, Y Incorporated is a mere alter ego of X Corporation. Questions. Should Mr. P be held liable? Explain. Should Y Incorporated be held liable? Explain. Suggested answer. Mr. P is not liable. The corporation, being a mere artificial person, can only act through its representative. The corporate representative is not liable for any act taken on behalf of the corporation unless he acted in bad faith or with gross negligence in directing the affairs of the corporation or made himself liable solidarily with the corporation. In this case, P, as president, signed the loan document not for himself but on behalf of X Corporation. Nothing in the facts indicated show that he bound himself liable with the corporation or he acted in bad faith or with gross negligence. Y Incorporated is not liable. Interlocking shareholders, directors, and officers per se is not enough reason to set aside the separate legal personalities of X Corporation and Y Incorporated. Piercing the corporate veil based on the alter ego theory requires the concurrence of three elements, namely 1. Control, not mere majority or complete stock control, but complete domination not only of finances, but of policy and business practice with respect to the transaction attacked, so that the corporate entity as to the transaction had at that time no separate mind, will, or existence of its own. 2. Such control must have been used by the defendant to commit fraud or wrong, to perpetuate the violation of a statutory or other positive legal duty, or dishonest and unjust in contravention of plaintiff's legal right. And 3. The aforesaid control and breach of duty must have proximately caused the injury or unjust loss complained of. Control, then, is not enough. The facts do not show that the control over the corporation was used to perpetuate fraud or violate a positive legal duty in contravention of J. Bank's right, and that such control and breach of duty was the proximate cause suffered by J. Bank. Question A5. Mr. Y filed a case captioned as injunction with prayer for status quo order, temporary restraining order, and damages against Z Company to prohibit the latter from selling shares which Mr. Y purportedly bought from Z Company. Mr. Y alleged that the subscription for the said shares was already partly paid by him, but the subject shares were nonetheless being offered for sale by Z Company to the corporation's other stockholders. Questions. Is the case filed by Mr. Y against Z Company considered an intracorporate dispute? Explain. Assuming that it was Z Company which instead filed a case against Mr. Y in order to collect the unpaid balance of his stock subscriptions, is the case considered an intracorporate dispute? Explain. Suggested answer. The case is not considered an intracorporate dispute. To determine if a case involves an intracorporate dispute or controversy, the Supreme Court has consistently applied two tests: the relationship test and the nature of the controversy test. Under the relationship test, an intracorporate controversy arises when the conflict is between the corporation, partnership, or association and its stockholders, partners, members, or officers. The nature of the controversy test examines the controversy in relation to the enforcement of the parties' relative rights and obligations under the Corporation Code and internal and intracorporate regulatory rules of the corporation. It is not yet certain that Mr. Y is a stockholder of Z Company. Thus, the first test is not present. Even assuming that the parties are stockholders of the corporation and, as such, satisfy the relationship test, the dispute is not rooted in the existence of intracorporate relationship. The action for injunction to stop the sale of shares does not pertain to enforcement of parties' rights and obligations under the Corporation Code. Yes, both relationship and nature of controversy tests are present. The dispute is between the stockholder and the corporation. The issue of unpaid subscription pertains to the enforcement of their rights and obligations under the Corporation Code. Question A6. In January 2016, Mr. H was issued a life insurance policy by XYZ Insurance, wherein his wife, Mrs. W, was designated as the sole beneficiary. Unbeknownst to XYZ Insurance, however, Mr. H had been previously diagnosed with colon cancer, the fact of which Mr. H had concealed during the entire time his insurance policy was being processed. In January 2019, Mr. H unfortunately committed suicide. Due to her husband's death, Mrs. W, as beneficiary, filed a claim with XYZ Insurance to recover the proceeds of the late Mr. H's life insurance policy. However, XYZ Insurance resisted the claim, contending that 1. The policy is void ab initio because Mr. H fraudulently concealed or misrepresented his medical condition, which is his colon cancer. And 2, as an insurer in a life insurance policy, it cannot be held liable in case of suicide. Rule on each of XYZ Insurance Company's contentions. Suggested answer. The first contention is not tenable. Under the incontestability clause, after a policy of life insurance made payable upon the death of the insured shall have been enforced during the lifetime of the insured for a period of 2 years from the date of its issue or of its last reinstatement, the insurer cannot prove that the policy is void ab initio or is rescindable by reason of the fraudulent concealment or misrepresentation of the insured or his agent. Even if Mr. H had concealed or misrepresented that he was previously diagnosed with a colon cancer, XYZ can no longer rescind the policy since it has been in force already for 3 years. On the second contention, XYZ Insurance is liable despite the suicide of Mr. H. Under the insurance code, the insurer is liable when suicide is committed after the policy has been enforced for a period of 2 years from the date of issue or its last reinstatement. In this case, Mr. H committed suicide 3 years after the issuance of the policy. Thus, XYZ Insurance should be held liable to the beneficiary of Mr. H. Question A7. Miss J offered to sell her car to Miss K, an interested buyer. Consequently, Miss J emailed Miss K a copy of the proposed deed of sale covering the same. After agreeing to its terms, Miss K printed and then signed the emailed copy of the deed of sale. She then faxed it to Miss J, who signed the faxed copy. Is the copy of the deed of sale faxed by Ms. K to Ms. J considered an electronic document under the Electronic Commerce Act? Explain. Suggested answer. The copy of the deed of sale faxed by Ms. K to Ms. J is not an electronic document. The Supreme Court has already ruled that a facsimile transmission cannot be considered as electronic evidence. It is not the functional equivalent of an original under the best evidence rule and is not admissible as electronic evidence. Question A8. KLM Printers Incorporated operate a small outlet located at the ground floor of a university building in Quezon City. It possessed soft copies of certain textbooks on file and would print book alikes of these textbooks, or in other words, reproduce the entire textbook upon order and for a fee. It would even display samples of such book alikes in its stall for sale to the public. Upon learning of Kale and Printer's activities, the authors of the textbooks filed a suit against it for copyright infringement. In its defense, Kale and Printers Incorporated invoked the doctrine of fair use, contending that the bookalikes are being used for educational purposes by those who avail of them. Questions. What is the doctrine of fair use? Is Scale and Printers' invocation of the doctrine of fair use proper in this case? Explain. Suggested answer. Under this doctrine, the fair use of a copyrighted work for 1. Criticism, comment, 2. News reporting, 3. Teaching, including multiple copies for classroom use, and 4. Scholarship, research, and similar purposes is not an infringement of the copyright. In determining whether the use made of a work in any particular case is fair use, the factors to be considered shall include A. The purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. B. The nature of the copyrighted work. C. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And D the effect of the use upon the potential market for or the value of the copyrighted work. Based on these factors, the invocation of the doctrine of fair use is not proper. The reproduction of the copies is commercial in nature, where the entire book is reproduced, thereby violating the economic right of the author, and the other offer to the public of copies of the book has an injurious effect upon the potential market or value of the copyrighted work. Question A9. X Pharmaceuticals Incorporated has been manufacturing the antibiotic ointment Marvelopis, which is covered by a patent expiring in the year 2020. In January 2019, the company filed an application for a new patent for Disilopis, which, although constituting the same substance as Marvelopis, is no longer treated as an antibiotic but is targeted and marketed for a new use, which is skin whitening. Questions. What are the three requisites of patentability under the Intellectual Property Code? Should X Pharmaceuticals Incorporated's patent application for Disilopis be granted? Explain. Suggested answer. The requisites of patentability are novelty, inventive step, and industrial applicability. Novelty. An invention shall be considered new if it forms part of a prior art. Prior art shall consist of everything which has been made available to the public anywhere in the world before the filing date or the priority date of the application claiming for the invention, and the whole contents of a published application for a patent utility model or industrial design registration filed or effective in the Philippines with a filing or priority date that is earlier than the filing or priority date of the application. Inventive step. An invention involves an inventive step if, having regard to prior art, it is not obvious to a person skilled in the art at the time of the filing date or priority date of the application claiming the invention. C. Industrial applicability. An invention that can be produced and used in any industry shall be industrially applicable. No, the patent application for this silopis should not be granted. The use of existing patent, although for a different purpose, will not satisfy the steps of novelty and inventive step. Finally, A10. In 2005, W Hotels Incorporated, a multinational corporation engaged in hospitality business, applied for and was able to register its trademark W with the Intellectual Property Office of the Philippines, or IPO, in connection with its hotels found in different parts of the world. In 2009, a Filipino corporation, RST Corp., filed before the IPO a petition for a cancellation of W Hotel Incorporation's W trademark on the ground of non-use, claiming that W Hotels Incorporated failed to use its mark in the Philippines because it is not operating any hotel in the country which bears the W trademark. In its defense, W Hotels Incorporated maintained that it has used its W trademark in the Philippine commerce, pointing out that while it did not have any hotel establishment in the Philippines, it should still be considered as conducting its business herein because its hotel reservation services, albeit for its hotels abroad, are made accessible to Philippine residents through its interactive websites, prominently displaying the W trademark. W Hotels Incorporated also presented proof of actual booking transactions made by Philippine residents through such websites. Question: is W Hotel Incorporation's defense against the petition for cancellation of trademark tenable? Explain. Suggested answer. The defense of W Hotel is tenable. Having a hotel establishment in the Philippines with trademark W is not the only way to prove actual use of the trademark. In one case, the Supreme Court ruled that the use of the trademark on an interactive website sufficiently showing an intent towards realizing a within state commercial activity or interaction is considered actual use to keep the trademark registration in force. That W Hotel was able to present proof of actual booking transactions made by Philippine residents through such website proves that the use of its W mark through its interactive website is intended to produce a discernible commercial effect or activity within the Philippines, or at the very least, seeks to establish a commercial interaction with local consumers. This is enough to keep its trademark registration in force. And with that, it's the end of part one. Thank you so much for watching and happy studying. All the best. Pinay Jurist on YouTube. Bye.